The current phase through which our country is going through, it doesn't look like we're going to get out of this quite soon. If you look at our country, I mean, it basically is a country that's sharply divided between those a minuscule population that has access to rights, that has fundamental rights, that has economic rights, that has various social rights, and those who don't. From a very economic point of view, I mean, it's accepted that more than 90% of our population actually lives in the informal economy. People who live on daily wages, who without work for a single day, don't have any kind of access to food or guarantee of shelter or education for their children, or any kind of access to health, as it were. The coronavirus and the unplanned lockdown that was declared on 24th of March literally hit at the very basic survival of these communities. One of the most visible impacts that we saw was on the migrant workers, and it was the lakhs of migrant workers who had to take to highways to try and reach their houses. A very simple question of why they did that. They had no work, they had no wages, they had no shelter, no access to food, and of course they also had the fear of what's going to happen to their families, and they wanted to be with their families. While everyone was told to stay at home, the kind of lockdown that happened meant that they were kept away from home. And these workers then took things into their hands, and they decided that if the state is not going to recognize their rights, they're going to walk. And in the face of that, we had a central government that actually told us to clap our hands and light candles and so on and so forth, and didn't have really much of a response to what people needed. Belatedly, of course, there were certain packages that were announced, and we all know that those packages were just insufficient to actually meet the basic needs of people. It was in this circumstance that people actually reached the courts, and they sought for some kind of a resolution.
Could the courts have done something in these matters? Now, the courts have reacted, especially I am talking about the Supreme Court. The Supreme Court has had two responses. At one level, it says that some matters are matters of policy, so we will not go into that. It's for the government to decide. And the second thing which it has said is that even if we go into some issue here and there, okay, we will leave it to the we feel the government is doing its best, and therefore we don't want to interfere. So at one level it says that these are matters of policy, matters of expertise, and we are not equipped to deal with these issues. And secondly, they say that even when we can go into these issues, the government has been doing sufficient, and there are sufficient work, taking sufficient adequate steps, and therefore we do not want to interfere. That's the second thing with the government is concerned. As far as matters of policies are concerned, yes, there are certain policies in which the court cannot go into, or will not go into, or doesn't have the expertise to go into. For instance, whether the lockdown should have been imposed on 23rd, on 24th, or 25th of March, or whether the lockdown should at all have been imposed, is a matter which the court would not go into unless there is a legal issue, unless there is a purely legal issue involved, whether the lockdown can at all be imposed under some law. If the policy is against fundamental rights, is irrational, or is arbitrary, then the Supreme Court can interfere in such policy matters. This is the settled law. Okay? So just because something is a policy matter does not mean the Supreme Court will put its hands up. It will still examine it, see whether it's right, see whether it's against fundamental rights, and then decide whether the policy is valid or some other policy should be in its place. But this is so to say that to say that we will not interfere in policy matters is something which is completely incorrect, and something which flies in the face of Supreme Court's own judgments in earlier times.
While in the past the Supreme Court has given effect to the Constitution's transformative purpose, for example, in its finding that there is a constitutional right to a minimum wage, that reservations are a facet of equality and not exceptions to it, and in the decriminalization of homosexuality. But in the last few years, the court has increasingly begun to act as an executive court. That is, a body that is less concerned with enforcing rights and standing as a bulwark between the individual and the state, and more with acting as a branch of the executive.
The Supreme Court should never have believed, should never have, or at least never have accepted the central government statement on the state of affairs. It should have tried to independently verify whether what the central government is saying is correct. If the central government is saying that everybody is getting food, the Supreme Court should have appointed some independent observers to visit some of the areas, maybe some slums, maybe some shelter homes, maybe some other areas, to find out, okay, whether what the government is saying is correct or not. Because every day the media was reporting that it is not correct.
The government ordered a nationwide lockdown, which also entailed the closure of industries and establishments. This action of the government essentially divided the citizenry into two halves: those whose job requirements allowed them to work from home and thereby, in a sense, continue working, and those whose job requirements required physical presence to work. It's both intuitively evident, but also has been borne out by many surveys, that the ability to work from home is directly linked to socioeconomic status. That is, the richer you are, the more likely your job will enable you to work from home. It is in this context that, for example, the constitutional right to equality becomes important. Transformative equality is not just a formal requirement, but sensitive to background socioeconomic context and to the effects that policies have upon those who are already vulnerable and marginalized. It is evident that the lockdown had an unequal effect on people based on their socioeconomic status, which gives rise to enforceable equality claims under the Constitution. Indeed, the government's failure to mitigate this issue led to other problems, such as a huge migrant crisis, which occurred because of the closure of establishments and the absence of work.
Migrants who have been unemployed for more than one month, trains are going to be started. Okay, daily rated migrants. So the question is, who is going to pay for them? Matter goes to Supreme Court. What does the Supreme Court say? Supreme Court says that whether to provide train fare or not is a matter of policy. We are not going to interfere. Matter ends there. Okay. So migrant workers matter comes to an end. Then, looking at the plight of the migrant workers, and millions of them, okay, retired Supreme Court judges, they write letters. Senior lawyers address letters to the Supreme Court saying, what the hell are you doing?
Given the circumstances, was it not the constitutional obligation, not duty of the Supreme Court, a court for the people of India and not a court of the people of India, to ascertain that a few lakhs, or not thousands, of migrants are well taken care of physically and emotionally? It is not that the court was expected to disbelieve or distrust the establishment represented by none less than the Solicitor General. The court was only required to ensure through the principle of continuing mandamus that the solemn assurances given to it are faithfully carried out. Sorry, the court completely failed in this.
Finally, the Supreme Court realizes that the criticism has become too much. And so on 27th May, they decide that we'll take suo moto action about migrant laborers. And then they pass some orders. Okay. But this is 2 months too late. A lot of people have died. A lot of people have virtually starved during this period.
So various organizations, including the People's Union of Civil Liberties, All India Central Council of Trade Unions, the Safa Karamchari Union from Bangalore, they all came up with various reports on how people's basic needs were not being met, the fundamental rights were being violated, and wrote letters to the Chief Justice, which were entertained as letter PILs. And pursuant to that, from 26th of March till now, you've had a series of orders in the nature of a continuing mandamus, which the court has passed, which to a large extent has meant that at least the state government has been forced to acknowledge the kind of crisis people are going through and come up with certain solutions for it, which to some extent have ameliorated the situation. So in the first phase of lockdown, when there was no movement itself permissible, food security became a very, very big issue. And this was an issue that was faced by a majority of the population, those living in the slums, those living in informal settlements, those living in low-class colonies, worker colonies, and of course the migrant workers. The state government and the central government at that point did not have any kind of a policy or any kind of understanding of how serious this entire issue was. And while it of course said that we will give rice and wheat to those who have ration cards, the question arose of what about those who didn't have ration cards. And when PUCL argued before the High Court that on the basis of the Supreme Court judgment in the Swaraj Abhiyan case, that even those who don't have ration cards should be given rations, this forced the government to come up with a policy decision that ration kits will be given to every single person across the state that required that was in need of food grains at that point in time. In no unmean terms, this was a consequence of the manner in which the court conducted the proceedings during this entire time, highlighting at every juncture that this was a question of Article 21, and the state and the government was duty bound to ensure that right to food of people was respected. Similarly, when the question of migrant workers was raised before the court, initially of course the question of them getting access to food grains, which was covered by these orders, then the question of them travelling back. The court was sensitive enough to understand that these are workers who have not been paid their wages, who have lost their jobs, and who do not have money on their hands to travel back. So when the Karnataka state government unilaterally actually would be a wrong thing to say, it decided on the recommendation of the builder lobby and the other management lobbies in the state not to allow any migrant workers to go back, and that they will be forced to stay back here. And there was of course a huge protest that the AICCT undertook along with the workers. But it was when it was brought before the court said that this was absolutely unacceptable. People have the right to travel. It's 19(1)(d), it's Article 21, and you cannot compel people to stay back. So then the state government of course withdrew its decision and started running trains, but was charging workers anywhere between 850 rupees to 1200 rupees for trains, which again workers were not able to, could not afford, and many of them actually fell into a debt trap on account of this. When this was argued before the court to say that it was the state government was duty bound to ensure that free trains should be ensured, after a series of hearings, finally the state government, without doubt, under recognizing the mood of the court, was compelled to actually withdraw its decision, and thereafter free trains have been run.
Similarly, employment. Government itself came out with an order which said that the employers are bound to pay employees during lockdown period, even if they have not worked, because in lockdown it's not possible to work, but the employers must pay the employees. Okay. Of course, this they withdrew after some time, but at least during the period when it was in operation, the employers should have paid. Okay. Because employers are in a much better situation than employees. Matter goes to Supreme Court. What does the Supreme Court say? Supreme Court passes an order saying that no coercive action should be taken against employers for not paying during. So even those who are going to pay or who are paying, stop paying. Similarly, you look at the situation of PM Care Fund. PM Care Fund is started despite there being already a fund which is available to the government for relief during disasters. Yeah, there is already a fund available since decades, but and that is audited by CAG, etc., Controller and Auditor General of India. Now suddenly a new trust is started. The Prime Minister is the head. That trust is not to be audited by the Controller and Auditor General. That trust is not susceptible to Right to Information Act. So nobody knows how much money comes in. Nobody knows what is happening to that money. Okay. So people challenge it in the Supreme Court, saying that how come this kind of trust? How come hundreds of crores are being received in this kind of trust? Okay, and this is completely illegal. That you can't collect people money for hundreds of crores of people and not be accountable to anybody. Supreme Court says no, sorry, this is a political issue. We will not go into it. Close it out. If you see consistently, the Supreme Court has failed on migrant issue, on food and ration issue, on COVID, on the PM care issue, on employment issue. There has been a systematic failure of the Supreme Court, okay, to intervene in a matter which is not even a political matter, which is a humanitarian matter, which is a matter where it's not like Kashmir, or it's not like Northeast, or it's not like an issue concerning security of state. It's a humanitarian matter, and if you refuse to intervene even in humanitarian matters, then I'm sorry. Though I may have to obey the Supreme Court, my respect for Supreme Court has completely gone down.
But Baba Sahib Ambedkar spoke about the the question of constitutional morality. That is the paramount reverence for the forum, for the forms of the Constitution, and of course, it not being something that is natural, but one that has to be cultivated. I believe that my understanding of the orders that have been passed by the various high courts fall within the category of those judges who are bound by constitutional morality and who have an understanding of a violation of fundamental rights at its root level, and decide that we will pass orders that are in keeping with the Constitution. So if you were to read any of the orders that were passed by any of the high courts, at no point can one see it getting into the realm of determining what policy should be. It always confines itself within the realm of the Constitution and protection of the constitutional rights. But of course, I mean, I think there's no two ways. One has to admit that these orders that have been passed by some of the high courts have provided succor to a lot of to large sections of society. But like someone said, the rights that depend on the goodwill of the courts really cannot be secure. And if you look at today and you look at the kind of challenges that are posed before society, the economic and wealth disparity, and of course the specter of fascism that looms large before us, we cannot say that courts will only be the only forums where this will be fought. This will necessarily have to be fought outside of that. But having a judiciary which is bound by constitutional morality in no two ways will actually help us in that. And I feel that some of these decisions that I referred to of these various high courts probably give us an indication of that.
We can only hope that going forward the Supreme Court will remember once more its obligations to enforce transformative constitution, to enforce the guarantees of transformative equality and freedom in the context of COVID-19, the wide-ranging and often draconian state measures that have been taken in the context of COVID-19, and what individual rights need to be protected in that framework.
It is in these circumstances that the Supreme Court and the Constitution are tested. Normal times they are there, you use the Constitution, you use the Supreme Court, High Courts, etc. But the real test of how strong how independent and how justice oriented the Supreme Court is would be in times of these kind of crisis. Up till now it has failed. I hope that in future there is a retraction and it succeeds. And it succeeds in giving justice to people. But if one goes by what has happened in the last 4-5 years, it has failed completely. The Second thing, which is also equally important from this, is that we need to look at the state of exception not only from the point of view of the state acquiring rights or state acquiring powers which it doesn't have during normal times, but also that during a state of exception, your civil liberties are restricted, like it is happening in COVID times. That because it's in exceptional times, in public good, in the need of the for the benefit of the people, we are going to restrict your liberty to move out of the house. We are going to restrict your liberty to move around, etc., etc., to assemble, to peaceably assemble, etc. We are going to restrict all this. Yeah. Now, in that situation, as I mentioned earlier, the human rights or the directive human rights, which are basically encompassed in the directive principles, okay, are directly impacted. Okay, so your right to livelihood, your right to food, your right to healthcare, etc., gets directly impacted, though it is prescribed under the directive principles of state policy. And therefore, in these kind of emergencies, okay, we should be able to argue that when the curtailment of my fundamental rights leads to a curtailment of my human rights, those human rights which are curtailed directly because of the civil liberties or fundamental rights being curtailed should now in these situations be treated as fundamental rights, push themselves from being just directive principles into being fundamental rights, push themselves from chapter 4 of the constitution into push themselves into chapter 3 of the constitution, and should be treated as fundamental rights with all the remedies available for implementation of fundamental rights, namely approaching the courts, demanding food, demanding healthcare, demanding various other facilities which are being denied because you are curtailing the civil liberties, because you are taking away employment, you are taking away various other things. So those rights. So this is something which should be argued. I hope jurisprudentially this is accepted by the courts over a period of time, because that's the only way we can deal with this situation.